1.
This Honorable Court of Appeals of Tennessee is in session.
Good afternoon. On behalf of Judges Stafford and McBrayer, welcome to the Court of Appeals. Today's hearing will be pretty much like it would be if we were all together in a courtroom. If we have any troubles, any technical glitches or whatever those things are called, we'll stop, we'll get it fixed, and then we'll go on. So don't worry about that. In the absence of any announcements, would you call the case, please?
Dennis Owen versus Kenneth A. Grinspun et al.
All right, is the appellant ready?
Yes, Your Honor.
All right, you may proceed.
I may it please the court. I'm Bill Walk. I'm from Memphis, and I've talked to the clerk. May I request 5 minutes rebuttal time?
You may. Granted.
Thank you. And if I may proceed, I appreciate it.
Sure.
Perhaps the trial judge, Judge Young, said it best when he said, if there was ever a case that was right for equity, it's this one. I can't give you the relief, but maybe the Court of Appeals can. This case is a sad case from the standpoint of the pandemic. And if I may give you a brief recitation of the facts, Miss Owen was, we believe, the victim of medical negligence in July of 2019. She ultimately hired us, and in July of 19, we filed the appropriate notice of intent to sue letters. In early November, I talked to her, and she seemed seemingly well. But much to my chagrin and to everyone else's, on November 17th, she died unexpectedly. In the pandemic, her husband of countless years, elderly gentleman, was really at a loss on what to do, how to do it, as many people were stuck during this time of no funerals, all of the things that were going on during the pandemic. The first thing he thought of, nor the 10th thing he thought of, was, let me call my lawyer and tell him that Alice is died in the event that it changes the status or how we proceed in the lawsuit. Nevertheless, we filed the lawsuit on November 25th, and we named the deceased, Alice Owen, as the defendant or as the plaintiff, not knowing that she was deceased. Then in December, apparently after he got a copy of we mailed him a copy of the complaint, Mr. Owen called me and said, hey, we had this discussion about his wife. Very sorry, very sad to hear. And in due course, we notified the defendants. We filed, we prepared a consent order of substitution, which they both kindly agreed to. They went about answering. We started discovery, and it was in the spring that they filed their motion to dismiss. And in the trial court, they filed their motion to dismiss, and Judge Young granted the motion on the McCormick case based on the nullity rule, in that, as this court's well aware, that she did not exist at the time, so therefore it was a nullity. And our appeal in this court, in this case, if the court pleases, is three levels. One is that we believe either the nullity doctrine does not apply, or it is very much out of step with modern jurisprudence, with the rules of civil procedure, rules 15, rule 17. Number two, we believe that if there was the nullity doctrine, that they waived it by entering a consent order. In the McCormick case, in which they rely, the defendants immediately objected when told about the death. In this case, they consented, they went on with discovery and the like. Or number three, that this court should equitably toll the statute of limitations based on the circumstances under the pandemic, under what was going on with Mr. Owen at the time. And so we get into Rule 15 and how this interplays, because there, Rule 15 and Rule 17, and then there are a few cases that we cite in our brief. And Rule 15, as every practicing attorney and judge knows, this is a rule to be applied liberally, allowed parties to amend, to relate back. Had Miss Owen died during the pendency of this lawsuit, had she died 1 month later, there would absolutely be nothing happening here. We would have filed a motion to amend. The court would have granted it, the lawyers would have accepted it, and it would have related back to the original statute of limitations. but due to this unfortunate set of timing and circumstances, we're put in a totally different circumstance. And in the Rule 15, the three requirements are that one, the defendant receive adequate notice. Well, there's no doubt that the defendants received notice letters, they received the complaint. It's exactly the same case, the same set of facts, and really the same real party in interest, which is also a factor. Number two, would the relation back unfairly prejudice the defendant? Well, of course not, it wouldn't. It's the same set of facts, the same parties. Nothing has changed in this lawsuit. Nothing would require them to change their defense, their procedure, their litigation. Nothing changed. And number three, is the identity of interest between the original party and the new one? Is there an identity of interest in the new one? Well, of course, this is the husband who inherited the cause of action through his wife. In fact, he would have had a potential consortium claim had we continued. And so when we get to that, Rule 15, we say should apply, but then you get to Rule 17, and Rule 17 of the Tennessee Civil Procedure says every action shall be prosecuted in the name of the real party in interest, and it goes through it. And then at the bottom part of that, it says no action shall be dismissed on the ground that is not prosecuted in the name of the real party in interest until a reasonable time has been allowed after objection for ratification or commencement and the like. And that's interpreted in the Chapman case. And one of the quotes is, there's no doubt the reason for this liberal policy in wrongful death cases has been the fact that the cause of action is not changed by the substitution of the proper party for improper plaintiff, and that such substitution does not prejudice the defendant who had notice from the beginning of the suit and the nature of the cause of action. And it really is, the provision was added in the advisory committee notes on Rule 17. The notes simply say, the provision that no action can be dismissed on the ground that is not prosecuted in the name of the real party in interest until a reasonable time has been allowed after the objection has been raised for ratification substitution is added simply in the interest of justice. The provision keeps pace with the law as it's actually developing. Modern decisions are inclined to be lenient when an honest mistake has been made in choosing the party in whose name the action is filed. Well, there's no question in this case that this is an honest mistake. There's no nefarious means. In fact, I see Judge Stafford there. Years and years ago, Judge Stafford and I had a case called Ertu Swastige, where an illegal immigrant had filed the action under an assumed name. He had changed his name in the U.S., and when it was determined in the middle of the litigation, the trial court dismissed the case. And I remember the oral argument with Justice Stafford, because the argument was, well, Norma Jean Ray and Marilyn Monroe were the same people. So would that be, is that a difference? Is that a problem? The Court of Appeals said, no, it's one and the same. I think Justice Stafford wrote that opinion. And so in this case, the real party in interest is really the same entity, the same person. The wife has died, and now it is her husband. There's nothing changed. The Fund Liquidated Holdings case, the Second Circuit case, they had the same thing. They said that the nullity doctrine really it was a non-existent party. The administrator had closed down the estate and then filed suit, and the theory was, well, the administrator or the estate didn't exist. Second Circuit reversed and said, well, no, we're not going to hold it up for that reason. We're not, and here's what they said. They said, we hold that Article 3 is satisfied as long as a party with standing to prosecute the specific claim in question exists at the time the pleading is filed. If the party, real party in interest, is not named in the complaint, then it must ratify, join, or be substituted into the action within a reasonable time. Only if the real party in interest either fails to materialize or lacks standing itself should the case be dismissed for want of subject matter jurisdiction. In this case, this was ratified clearly and quickly. As soon as we found out, we said, send a substitution of party order. It was agreed to. There was no delay. There was no funny business. It all worked out in that way.
Is the McCormick case the only case on the nullity rule? Are there any others in Tennessee?
I think the McCormick case cites to past older cases. One of them is from 1846, but that was the case that the court relied upon when issuing the ruling. And that's the case that has been primarily relied on by the appellees. And so the thrust of the argument is that in today's modern era with the rules of civil procedure, rules 15, rule 17, that it's antiquated to try to use the nullity doctrine to try to eliminate this during the pandemic when this elderly man did not think to call his lawyer that his wife had just died. And he did call within a couple of weeks and it was rectified. And again, it falls through the cracks. And again, the McCormick, we could argue also that the waiver occurred, that they agreed to the order of substitution to counsel. And that was generous on their part. That I appreciated them doing it. We sent them a death certificate. They agreed to it. It was generous on their part, but it did act as a waiver. And so we would argue, I mean, my primary argument is the nullity rule shouldn't apply. Obviously, the second is a waiver. And then third, at the very least, doing in the interest of equity to extend the statute of limitations based on the pandemic and the situation. And with that, I sit down.
Thank you very much. Appellees, I understand you're splitting your time.
Yes,
Is that
Judge
correct?
Bennett. This is Danny Rader on behalf of Dr. Grinspun and Upper Cumberland Orthopedic Surgery. Appreciate the opportunity to be before you today. I'll take the first 7.5 minutes and then Ms. Warwick has the next part if it pleases the court.
All right.
May it please the court, with all due respect to Mr. Walk, there are a number of cases that this court and the Supreme Court have consistently held that the survival statutes in Tennessee have to be strictly construed because as the court recalls, the common law was all lawsuits, all actions abated at death. And so the survival statutes are in derogation of the common law, and so they have to be strictly construed. And courts dismiss cases all the time under sympathetic circumstances and sympathetic matters like this. Sympathetic facts do not warrant wholesale changes in the law and predictability. And that principle has underscored the statute of limitations. It's underscored all number of principles that we rely on. This court twice and recently has addressed the nullity rule. In the McCormick case, this court very clearly said, we hold that under Tennessee law, the commencement of a suit in the name of a deceased individual amounts to a nullity, and that such a nullity may not be avoided through substitution of parties. And just 3 days after Ms. Owen died, and several days before the lawsuit was actually filed, this court reaffirmed the principle in Jones versus Martin. Judge Golden on November 20th, 2020, addressed that matter and said, quote, no question, such a filing would be a nullity under the McCormick decision, close quote, if that suit had been filed in the name of the deceased individual. In Jones, of course, it was not filed in the name of the deceased individual, but this court has very, very firmly used its language, Judge Hires and Judge Golden, specifically in those two fairly new cases, applying the nullity doctrine. And this is not an obscure doctrine that is ancient and no longer applied. Through the briefs in this case, I counted at least 10 states and a number of different federal district courts in West Virginia and Missouri and others, as well as the Sixth Circuit in a recent case from 2012, the Zurich insurance case, the Fourth Circuit Court of Appeals, all applying the nullity doctrine. And as we cited in our brief, this is black letter law. It's quoted in CJS. This is a uniformly applied doctrine throughout the country. And with all due respect to Mr. Walk, I think that if there were any cases that said that the nullity doctrine should be abandoned beside this fund liquidation holdings case from the Second Circuit that was about corporations and didn't have anything to do with people, I suspect we would have seen all of those cases in his brief, and there just aren't. So what the appellant is asking this court to do is to abandon a well-settled, well-accepted, broadly accepted principle of law that has been relied on for many, many decades and become among the minority view. And I respectfully submit that the court should not do that. And sympathetic facts should not compel this court to adopt a principle that will not be able to be constrained. And as the Second Circuit stated, quote, admittedly, this is not a view adopted by many courts, The far more common view is the so-called nullity doctrine, exemplified by Zurich Insurance Company versus Logitrans, the Sixth Circuit case, which says that a case initiated in the name of a plaintiff that lacks standing is an incurable nullity, close quote. And I think that that is exactly right. And of course, the Second Circuit case was that entire case, if you read that opinion in detail, is talking about Article 3 jurisdiction and standing with respect to constitutionality. Would it be constitutional to abandon the nullity doctrine? And that's what that case is talking about. It's not talking about the issues that are present before the court today, which is when a plaintiff has passed away and there is no suit to revive. Appellant talks about Rule 17. Rule 17 is no help, and that issue has been addressed. We cited the court in our brief to a 2015 decision in re asbestos litigation. That's a case from Pennsylvania, and it talks about Rule 17 and how it applies. Rule 17 only applies when there is an action. And of course, if there is a nullity, as there is here, then there is no action. And the court said, Rule 17 describes dismissing an action. However, if there is no legitimate action to dismiss, then Rule 17 is not relevant. Rule 17 only becomes relevant if the plaintiff has surmounted the prerequisite of presently existing. And here, of course, Ms. Owen did not exist. And this doctrine of capacity versus legal existence is what Rule 17 talks about. Rule 17 simply doesn't apply when there is no action to revive. And because it was a nullity, there was no action to revive. The 2015 decision that I'm referring to in re asbestos litigation lists litany of cases around the country talking about this, and they identify some other sympathetic situations. For example, there's a case that they discussed from the 11th Circuit where a federal district court in Florida dismissed 500 cases of deceased smokers who were trying to pursue claims against the tobacco companies and others because they were deceased at the time the lawsuit was filed. And the 11th Circuit Court of Appeals affirmed that dismissal under the nullity doctrine. And that concept is very well settled. And with all due respect to the argument of waiver, McCormick forecloses the argument of waiver. And of course, waiver would be an argument every single time the nullity doctrine would apply. But this court said, we find that an objection based on the fact that the plaintiff was deceased when the complaint was filed can be raised at any time during the proceedings in any appropriate manner. And such objection stops the cause at whatever stage it may be, whenever it may be known to the court. This is not an outdated decision from the Court of Appeals from the 40s or 50s. This is a current, recent decision from 2009. It was written by the presiding judge for the Western Section, Judge Hires. It was confirmed as recently as 3 days after Ms. Owen passed away in Jones versus Martin. If there is no action, then there can be no waiver. And with all due respect, the suggestion of death, according to the affidavit of Mr. Walk, he learned about Ms. Owen's death in December. The suggestion of death was not filed until the end of February. And the motion to dismiss was filed less than 2 months later. This was timely, properly presented. There was no waiver. There can be no waiver. If the initial suit is a nullity, as the courts have held, that cannot be waived. It's just like jurisdiction, it can't be waived. If the suit was never actually brought, then the claim cannot be waived. And with respect to equity, I understand the argument and I appreciate the argument for Mr. Walk, but the Tennessee Supreme Court has multiple times rejected the doctrine of equitable tolling in civil cases. In Norton, Farner, Red Wing, over and over again, they've said, we're not going to do that here in Tennessee, that we're going to require some affirmative misconduct by a defendant before we're going to apply equity in that circumstance. Thank you, Your Honors.
Thank you. Ms. Horak.
Thank you. May it please the court. My name is Whitney Horak and I represent Appley Integrity Healthcare of Salina, LLC, DBA Salina Health and Rehab on this appeal. While I as well understand Mr. Walk's position regarding the sad circumstances of this case, as Mr. Rader has argued, the McCormick decision is established precedent for this court. And Judge Stafford was on the panel for both McCormick and Jones v. Martin, which cited McCormick with approval. Mr. Wall argued regarding Rule 15, which is for a motion to amend. A motion to amend was not filed in this case. He did not seek to amend the complaint. So Rule 15 should not be considered for this court. And it also can be, the nullity cannot be cured by an amendment. In addition, so as Mr. Rader argued, the substitution could not cure the nullity. That was made clear in McCormick. And each of the cases cited by the appellant regarding substitutions that could cure the defect were not dealing with a deceased plaintiff at the time of the filing of the complaint. None of those cases were dealing with the nullity. Now, as to the fund liquidation case cited by the appellant, this court should not find the fund litigation case instructive. In addition to the Fourth and Sixth Circuits that Mr. Rader mentioned, the Fifth, Ninth, and DC circuits also follow the nullity doctrine, as well as 8 other states that I found in my research. It is an established doctrine in the United States, and the appellant has not given the court a sufficient reason to overrule McCormick. The Second Circuit's opinion expressly noted that it was the minority view and that the Second Circuit had not previously adopted the nullity doctrine, which is a distinguishing factor because this court has adopted the nullity doctrine in the past.
Excuse me, you said the nullity doctrine is a minority rule?
I'm sorry, no, the fund liquidation rule is the minority rule.
And you found 10 other states that have the same rule we do? Or
I found eight other states: Wisconsin, Massachusetts, Mississippi, Louisiana, Georgia, Illinois, Ohio, and Texas.
And what do the other states do?
The same as we do. They find that a suit filed in the name of a deceased.
I mean the other 42. Get my math
I could
right.
not find a case law on the nullity doctrine from other states.
Okay, thank you.
The fund liquidation opinion, or that rule, if this court were to follow that opinion, could lead to consequences such as encouraging placeholder lawsuits, wasted resources, or wasted court resources, or forum shopping. It could encourage counsel to file suits in the name of straw plaintiffs who may lack standing, while they search for proper plaintiffs that may never materialize, all the while causing courts and defendants to waste resources litigating a nullity or a fiction. That could also occur in cases in which there is a statute of limitations that is looming, and because of the fund liquidation rule, a party could file suit in the name of a John Doe, or a party that actually has no claim, but can file that lawsuit and waiting for the real party in interest to be ready to join the suit. This court should affirm the trial court's holding and hold that the nullity doctrine is the accepted doctrine in Tennessee. And as Mr. Rader argued, the agreed order of substitution did not waive the party's right to raise the nullity issue. The agreed order the parties cannot stipulate as to matters of law. Parties can only stipulate as to matters of fact. Therefore, the order did not waive the party's right to make this argument. And as Mr. Rader mentioned, the McCormick decision makes clear that this argument can be raised at any time in the proceedings. Appley's Integrity's motion for summary judgment was filed less than a month after our answer. We did not engage in discovery or delay after we were made aware of this defect. As to the issue of equity, the equitable tolling doctrine has not been adopted for civil cases unless in post-conviction proceedings, and should not be adopted under these circumstances. In Holland versus Florida, the U.S. Supreme Court noted that equitable tolling is not warranted for garden variety claims of excusable neglect, which includes attorney error. In Whitehead versus State, the Tennessee Supreme Court declined to adopt equitable tolling in civil proceedings and found that it should be used sparingly in only extreme cases that would lead to unacceptably unjust outcomes. And under these circumstances, I understand Mr. Walk's position to allow equity under this set of circumstances and in reference to COVID. It could lead to a floodgate of appeals due to COVID. But this was not the beginning of the pandemic. This was not March of 2020 when everything was shutting down, when courts were closing. This was November 2020. And while COVID was still a very serious issue, and it still is, we were starting to do Zoom. The oral argument in Jones v. Martin was via Zoom. People were adjusting to learning new ways to practice law and deal with the pandemic. So this is not a situation, respectfully, this is not a situation where equity, especially the equitable tolling doctrine, to be applied. For the appellees, request that the court affirm the trial court's order granting the motion for summary judgment. Thank you.
Thank you very much. Mr. Walk, I believe you have 5 minutes for rebuttal time.
Thank you, Your Honor, and I promise you I won't take up that 5 minutes. I just have a few comments to make. Firstly, I've been doing this about 32 years now, and they always say, the law's not settled until it's gotten right. And so in this case, I would urge that the law is not settled here until we get it right. Tennessee Constitution, Tennessee law throughout has always favored access to the courts by the plaintiffs, that the courts favor hearing and deciding cases on the merits and not on technicalities. Going back to the fund liquidation, what we'd argue is Mr. Owens, as the assignee and successor in interest to the cause of action belonging to his late wife, is the functional equivalent of the original plaintiff. And so in an assignee case, there is neither a new cause of action nor a new party or even a new lawsuit. It's just the same thing. And in the fund liquidation case, it says supporting this view is the fact that joining an assignee does not substitute a new cause of action over which there is subject matter jurisdiction for one in which there is not. Rather, a real party in interest who has been assigned the claim is the functional equivalent of the original plaintiff. And an assignee steps into the shoes of the assignor. And in this case, that's what we have. We not asking you to abandon the nullity rule as much as evolve into the modern era when we've got access to what we have. And in response to Ms. Horak, the pandemic was still going on in November and December. And in fact, for elderly people who were shut in and a man who had just lost his wife, I would respectfully argue that it was quite a stay in not knowing how to handle the funeral. There were no funerals still then. There were no ways to contact people. So yes, I think equity is appropriate in this case, but even more so, I think the law is appropriate. That Tennessee should evolve and understand that, no one is advocating a slippery slope or, ghost plaintiffs or using this law in any way other than in the terms of this particular facts of this case, where the right party by 7 days was missed because of a death that was unknown to the council. So in this case, Mr. Owens was a de facto plaintiff, was going to be the plaintiff. Had this happened a week after the file, we would have been in the same place. And so it's kind of a draconian result because of 7 days going the either way. And I know statute of limitations. We always say that the law favors people's access to the courts and people's hearing it on the merits, but every legislative law that comes down seems to claw a little bit away of that one at a time as far as what the requirements are for a plaintiff to have access to the courts. In this case, we did everything that we knew we could do to get access to the courts. We filed the notice letters, which are not required in any other kind of case. We filed, we had the complaint. the certification, all of the requirements for a medical negligence case were done. And in this case, poor Mr. Owen did not know to call us in advance so that we could change her name to his name. The facts are the same. The law is the same. The cause of action is the same. Nothing is different. And we didn't file a motion to amend for Rule 15. I'm asserting Rule 15 analogous to show that courts allow liberal amendments that relate back. This happens every day, all day. Ruling in favor of Mr. Owens here is not going to change the law. It's not going to be a drastic change in how we do business. Rule 15 and 17 allow liberal amendments, allow changing of parties, substitution of parties. This goes on every single day in the state of Tennessee. To have the Owens penalized because of the death of this lady a couple of days before the statute would seem unjust and unfair. And all we're seeking in this case is for this court to do justice on the behalf, just as a trial judge said, if any case was ever ripe for some equity, it's this one. And he said, I can't do it. Hopefully the Court of Appeals will. And so in this case, I urge this honorable Court of Appeals to do justice and to do equity and to follow the law and overturn the trial court's dismissal of this action. With that, I rest.
Thank you, Mr. Walt. Thank you, everybody. You've given us plenty to think about, and we appreciate that. Madam Clerk, would you please recess court?
This honorable court